What is the False Claims Act?
Well, the False Claims Act is a rather unique feature in the law. Most of the time when you bring a lawsuit, it's because somebody did something to you. But under the False Claims Act, it's possible for a private individual like yourself or like me to bring a lawsuit on behalf of the government when we're aware of somebody else cheating the government. So this would be for the federal government and as well for most states. I think most states have a Qui Tam False Claims Act provision.
What actions are considered violations under the False Claims Act?
One of the things I've learned is that fraudsters are incredibly inventive and imaginative. If there's a way to cheat the government, somebody has already thought of it and somebody's already doing it. But the key to a violation of the False Claims Act is that it has to be exactly that. It has to be somebody cheating the government. So, for instance, if a hospital is overbilling for a particular procedure, but they don't overbill Medicare or Medicaid, they just overbill private insurers or people who pay out of pocket, that's not a False Claims Act case. If they overbill Medicare and Medicaid, that's the key to a False Claims Act.
And who can file a Qui Tam action?
Anybody who's aware of that kind of cheating. You know, the False Claims Act was originally enacted by Congress back in Civil War days because there were contractors that were selling lame horses and muskets that didn't work and biscuits that were spoiled, that kind of thing, to the Union Army. And the government said, hey, we got to stop this, and we're going to enlist the public to help us do that. So that's where it came from. But since then, it's changed over the years, and nowadays, most of the fraud that is caught by the False Claims Act is Medicare or Medicaid fraud. But there's still a lot of defense contractor fraud and grant fraud. Anything that involves government money could be the target of fraud, and that can be fought through the False Claims Act.
And do I have to be an employee at an institution to blow the whistle?
No, not necessarily. It's always helpful to have insider information, because it's the people that are actually inside the institution, whether it's, a hospital or a defense contractor or whatever it happens to be. They have the most and the best information about what's going on. But it's possible, for instance, for a patient who's aware of their doctor's office overbilling, it's possible for that patient to bring a False Claims Act case. It's a lot harder because all they have is what they know, what happened to them. And actually, what often happens then is that people who are outsiders will try to get information from maybe former employees who've left the company, or other patients, in my example here, who have similar experience. So the more information you can accumulate, the better. But while insider information is best, it's not required that you be an employee.
Can I work with my colleagues to bring a Qui Tam action?
It's often better to work with other people because, different people know different pieces of what's going on. That said, two things you have to remember. Part of the sort of mechanism, really, of the False Claims Act is that people are encouraged to step forward to blow the whistle because there's a potential reward at the end. If you bring a False Claims Act suit and you're successful, the suit is successful, you're entitled as the whistleblower to between 15 and 30% of what the government recovers. That's under federal law, at least. States have different laws. So that encourages people to step forward as a whistleblower. So if you work with other people to bring one of these lawsuits, you need to share that reward, which might, change your incentive. The other thing to remember is perhaps more important, actually. It's only the first person who brings one of these lawsuits on a given set of facts who can recover. So, for instance, if I'm aware of my doctor cheating Medicare and being just a patient, I don't have access to insider information, but I know somebody who used to be the biller there. So I call that person up and I say, hey, do you want to work with me to bring a False Claims Act case? They might say, nah, I'm not really interested. And, it's too much trouble. I don't want to get involved, all of that. Then when they hang up the phone, they turn around and call their lawyer and say, hey, we got to beat Pat to the punch here. We got to get our case filed before he can. So if you're going to try to work with another person, it's important to trust that person, to know that, at least you have a good chance that they won't stab you in the back. And it's a good idea, actually, to have your complaint as near to finished as possible, so that if you call them up and they say no, you're able to file as soon as possible.
And what happens after the case is filed?
This is the other way in which False Claims Act cases are unique in the law. The complaint, well, there's a bias in the law towards public transparency. The courts are set up and the law is set up so that everybody knows what's going on when you file a lawsuit, a regular lawsuit. It's part of the public record. Anybody can go in and look it up. False Claims Act cases are different. Because you're suing on behalf of the government wants some time to investigate your allegations before the defendant even knows that they're being sued. So the case is filed under seal so that the government can do that investigation without the defendant being tipped off. Now, the law, federal law, again, different states vary, but federal law requires that the case stay under seal for at least 60 days. The government, in our experience, always, literally always, wants more time to investigate. So they can apply to the court for extensions. We've had cases that have stayed under seal for 5 years, 7 years, longer than that. The average is seems like it's about 2.5 years, something like that. But while it's under seal, the whistleblower can't reveal the existence of the case to anybody else, which sometimes makes it tough. But meanwhile, the government does its investigation. At some point, they finish that investigation, and then the government says one of two things. Well, we're going to take over the case because we found out, that it's a serious case, that there's a lot of this fraud going on. If that's what happens, if the government takes over the case, then we help however we can. If the government, for whatever reason, says, we don't want to pursue this case, we the government, then the whistleblower has the option to pursue it with his or her attorney. And depending on why the government declined, then that's how the whistleblower makes their decision to go forward. We would work with our client to figure out whether it even makes sense to go forward. We do a lot of declined cases. We continue to litigate them. But sometimes the government looks into the case and says, well, Mr. Whistleblower, sorry, you're just wrong. What they're doing is not actually fraud. Then obviously there's no point in pursuing it.
Let's say if I was involved in a fraud for a while. Does that mean I can't bring a Qui Tam now?
That's a little tricky to answer. Generally, no, it doesn't mean that. But there are some situations in which it wouldn't make sense for you to bring one. The law recognizes that most whistleblowers are going to have some involvement in the fraud, otherwise they wouldn't even know about it. So most whistleblowers come to us with a little dirt on their hands. That's usually not a problem. In fact, when the Senate was debating an amendment somewhere along the way, an amendment to the False Claims Act, one senator was quoted as saying, we know that it takes a fraud to catch a fraud. So that's kind of built into the process. But if you actually initiate the fraud, if you're the mastermind behind it, and especially if you profit from it yourself, and if you sit on your knowledge of it for, an extended period of time, then your odds of actually getting an award at the end diminish drastically. The government might say, well, thanks for bringing this suit, but get out of here, basically. It's even possible, although it's not too likely, But if you were egregiously involved with the fraud, it would even be possible that if you stepped forward, they might arrest you. So, think about how dirty your hands are before you start down this process. We certainly, advise our clients on that question all the time.
What if it turns out we're not the first to file?
That's an important question. As I was saying earlier, it's only the first person that files a complaint on a given set of facts that stands a chance to recover. Now, because these cases are filed under seal, there's no place to look before you file your complaint. There's no index to go to and say, oh, I see that, hospital so-and-so has already been sued, so I'm not going to do it. We have cases sometimes that we only find out that we're the second or third or even fourth to file years after we filed the complaint. The government, for whatever reason, the government sometimes sits on that knowledge and doesn't tell us that we're not the first to file. Now, often what does happen is that everybody sort of, once you find out that there are more than one relator on a case, you compare the complaints and try to see if there are claims that don't overlap. For instance, if my complaint alleges fraud about what's called durable medical equipment, back braces and that kind of thing, and the other relator's complaint accuses the same office of overcharging for certain injections, then our claims don't overlap. And I'm the first to file, even though I'm the second to file generally, I'm the first to file on that complaint, that claim, that set of facts. So in a situation like that, both suits could move forward. If there's complete overlap between the claims, then if you're not first to file, you're pretty much out of luck. Although sometimes the parties get together and try to work out an arrangement because, frankly, if you use all of the information from both or from however many there are suits, it's just that much stronger. But the first filer has no obligation to share anything with anybody else down the road.
What if I have external resources like newspaper, other cases? Can I use that information?
The law actually says that you can't base your case on information that is in certain enumerated public sources, news media, federal cases, or administrative procedures. There are a couple of others. But recently, there's been a growth industry, so to speak, in people doing what's basically data mining, sorting through public records and matching things up. So even though, source A is public and source B is public, there's no public knowledge, there's no general knowledge that when you put those two things together, it spells fraud. So there are people doing basically data mining, especially in Paycheck Protection Program loan cases, where there's been a fraud on the PPP program. You can put different data sources together and realize that, hey, this one at least looks fishy. So let's, maybe file a complaint about that. So there are ways to use public sources, but generally speaking, the law is looking for insider information that's not public.